Got a water bottle, sustainably.
It's just
I know.
Yeah.
water. Water bottle. You got those signs?
He's good at them.
Oh, it's not even.
I
For
wanted,
me, I feel robbed, Nat.
I wanted to follow that, by the way, but
I like it
I'm not
right under your nose though.
Oh, thank you very much. Can you give me a big high back?
Yeah.
Love to see you.
Silence will stand. The Coronial Court of the Northern Territory is now in session. Please be seated.
Dr. Freckleton.
Your Honour, we move now to our submissions in relation to what Your Honour can find and from our perspective in relation to Mr. Rolfe's use of force and what inferences you can draw that might be relevant to what occurred on the 9th of November. The Northern Territory Police Force accepts that Mr. Rolfe used excessive force on 4 occasions. We accept that there are entirely understandable positions that he may have used excessive force on others. And what we say is that judgments in relation to such matters are contextual and sometimes difficult. From a perspective of the force, they say that the 4 occasions were Araluen Park, Master TG, Albert Bailey and Tyson Woods. That is right. Or if Your Honour accepts something broadly similar to it, this may be capable of establishing that Constable Rolfe had a general propensity to use excessive force in arrest of Indigenous suspects on some occasions. However, the difficulty comes in extrapolating from those occasions to what occurred in relation to Kumanjayi. Now, as Your Honour knows, our position is that you should not be intruding upon what actually occurred with the firing of shots. So the question is then what use you can make of the inappropriate occasions in which Constable Rolfe used force against other persons in relation to what he did up to the point when he discharged his firearm on the 9th of November. What can be said immediately is that the arrest of Kumanjayi was markedly different to those other occasions, not least because Kumanjayi, to Mr. Rolfe's knowledge, had threatened police 3 days before. So real care needs to be used in extrapolating from those other occasions and drawing inferences that are pertinent to the circumstances of death. We do extensive submissions, and you and everyone else in the courtroom will be relieved to hear that we're not going to engage with those in any depth. What we have to say is at paragraph 298, following of our submissions. We submit that it is important not to use knowledge that you are privy to, Your Honour, that was not known to the Northern Territory Police Force in the sense of allegations having proceeded to finality in investigation and findings having therefore been arrived at in terms of force having been used in an excessive way. Some general matters can be identified. Firstly, Mr. Rolfe did not have a record of using force on a particularly high number of occasions when viewed in the context of his discharge of general duties in Alice Springs. He was identified by Sergeant Barham to have used force on 46 occasions between his first operational shift at the end of 2016 and 9 November 2019. Now, there might be some room to argue about that number. It may be a little more, it might be a little less. But assuming that that is broadly right, what Your Honour knows from evidence before you is that Mr. Rolfe did not appear at the top of an analysis of the use of force used by members during that period. It shows that he used force about once a month or on approximately 15 occasions a year while working in the front line in Alice Springs. It might be a matter of discomfort for all of us that members use force with such regularity in the Alice Springs area, but with respect, that's not really the point. The point is that in terms of his propensity to use force, which is he was not in the upper echelon. Next, it's important not to conflate the use of force with the use of excessive force. They're quite different categories. Sergeant Barham identified 5 of those 46 occasions as being an excessive use of force. They were Bojangles, Malcolm Ryder, Araluen Park, Todd Tavern and Albert Bailey. Ultimately, after their investigations, the Professional Standards Command, PSC, determined that only 2 of those were excessive. Then later on, the TG matter, Master TG, associated with the bin, and the Tyson Woods matters were reviewed and found to be excessive. Next, what can be identified is that the use of force in respect of those 4 matters was really quite different one from another. Only one, the Albert Bailey matter, could be described as a serious excessive use of force case, and it has not yet been finally determined. It happened when Constable Rolfe was having trouble sleeping and around the time when he was prescribed medication. We don't put that as mitigation in any way, but we simply observe that that seems to have been its context. But the other 2, Araluen Park and Master TG, did not involve specific injuries, and they fall at a lower end in terms of the excessive use of force, distasteful, though the Master TG and Araluen Park ones were on any reasonable analysis. Next, none of the complaints against Mr. Rolfe or investigations into him resulted in outcomes pursuant to Part 4 of the Police Administration Act. The Albert Bailey matter still has not been finally determined. It's unresolved pending the resolution of Mr. Rolfe's appeal against his dismissal, which is yet to be finalised. The Araluen Park and Master TG incidents resulted in provision of remedial advice. Next, no adverse findings about his use of force had been made prior to 9 November 2019. That's really important because it's a pity Mr. Rolfe is not here, but Mr. Rolfe was entitled to the presumption of innocence in relation to matters that were unresolved as yet. And moreover, when matters were still subject to investigation, it wasn't appropriate for action to be taken in relation to his service or the form of his service prior to that resolution. In 2022, only 3 years later, the Professional Standards Command determined that excessive force had been used in the Araluen Park, Master TG and Albert Bailey matters. Constable Rolfe was charged with a serious breach of discipline in respect of Mr. Bailey, and the Tyson Woods incident, of course, arose in the course of this inquest. The only formal feedback that he got in relation to use of force incidents was a request that he respond to the Professional Standards Command. Its assertion, and it does not seem to be contradicted by evidence, is that he never heard anyone say that his methods were unsatisfactory, excessive or unwarranted. Now, one might say that he should have been being told that, but then again, while we accept that better supervision, especially from some persons, and I'll say more about that in a while, should have been given, there's only so much the supervisor could do until there is proper resolution of an allegation. So at the end of that, what one can say is that the complaints about Mr. Rolfe may be capable of establishing he had a propensity or tendency to use force on some occasions, but that leaves things at a very high level of generality. And that does not enable inferences to be drawn about his reasons for or motivations in using force against Kumanjayi Walker after being stabbed by him. In none of the circumstances to which I have made reference was the offender armed, or did they strike or cause injury to him? Did he feel threatened, or was he of the view that he needed to protect a colleague from a threat? He didn't use a firearm in any of those cases. Kumanjayi, of course, was not running away. So to suggest that Mr. Rolfe had a propensity to use excessive force against Aboriginal people that was known to the police force, and that he continued unchecked to engage in that pattern of behaviour which culminated in the death of Kumanjayi, lacks cogency and rigour, and is not supported by the evidence that you have. It would be, in our submission, wrong to make a finding of that nature. I'd like to say just a few things about the use of dogs. General purpose dogs, also known as patrol dogs, are a tactical, non-lethal use of force option. They are well regulated. Members utilising a patrol dog are obliged to comply with use of force policies, most particularly including the requirement to use minimal force. Have to apply the 10 operational safety principles. They have to complete a use of force case note entry when a dog is used to apply any force to a person, and most assuredly if any injury is occasioned. They are used absolutely every day in the Northern Territory, as they are elsewhere in Australia. They're used in urban, regional and remote settings, generally in the context of providing operational assistance to other police. We accept that the use or presence of a police dog can be intimidating or frightening for members of the community, but that is the deterrent aspect to their operation which actually makes them useful. Their very purpose is to avoid other worse forms of force. It's very infrequent indeed that dogs actually apply force to any individuals. This is an emotive subject, but again, it needs to be looked at with rigour and care. Usually the mere presence of a dog is enough to achieve the objective. Usually they're not allowed off their leash at all. The dog is a low-level tactical option. Dogs can and do cause injuries on rare occasions, but it's very low. The alternatives can and do cause injuries as well. Batons, tasers, and similar. Usually, a police dog remains in the van of the handler until it's deemed appropriate for the dog to alight from the vehicle. As Senior Constable First Class Donaldson said, half the time the dog doesn't even get out of the car. Even out of the vehicle, the dog is not released or allowed off the lead unless circumstances require it. The police dog barks on command. It's trained not to bite unless explicitly permitted to do so. It's only deployed after a handler gives multiple opportunities to a suspect to surrender and warns them that if they do not do so, the dog will be released. If the command to bite is given, the dog is trained to track the person and then bite and hold to minimise the risk of injury until the handler can be in close proximity to the person. Your Honour has received data about the use of dogs. Senior Constable First Class Donaldson stated that the percentage of all deployments, namely when the dog comes out of the police vehicle, resulting in bites would be less than 1%. Between 2019 and 2021, there were just over 5,500 deployments of a police dog, 5686 to be specific. But only on 45 occasions was the dog used to apply force in any active way. Those 45 occasions, to put it in context, are 0.008% of the use of force by Northern Territory Police members during that time. Of those 45 occasions, when a dog was used, an injury was caused on 18 occasions. Most of those were minor lacerations, grazes, scratches and abrasions. Now, we concede, of course, that dogs must be used as little as can be orchestrated, wherever that is, whoever the suspects are. But it is erroneous, again, to speak in terms of patrol dogs being used against or on a person. They are used for particular purposes that are kept to an absolute minimum, and they constitute a tactical option that is likely and does involve less harm to suspects than other options. The issue of militarisation has been raised by Alan and friends as well. We have addressed that in some detail, and we don't propose to do it at length here. The raising of the issue by our learned friend has constituted a helpful opportunity to reflect on policing style and to consider measures that should be adopted to ensure that there is a clear delineation between military service and policing service, especially since in the order of a quarter of persons recruited to the Northern Territory Police Force have come from a military or other policing background in recent years. There's no doubt that militarisation of policing is an important topic of theoretical, criminological and policing scholarship. It also has the potential to have practical ramifications. Ultimately, what we submit to Your Honour is that it has minimal relevance and application to this inquest, both by reason of the scope of the inquest, the nature and quality of the evidence said to underpin arguments about militarisation as a matter of principle, including from Emerita Professor McCulloch, and the tangential nature of a link between any militaristic philosophies and practices on the one hand and the death of Kumanjayi on another. It is not enough to say Kirstenfold and Rolf had both served in the military. They used some military-style words, and you can pardon one for thinking that some of their behaviour had flavours of the military about it when they were in the vicinity of houses 577 and 511. That doesn't mean that that training had an impact on what happened inside room house 511. For a start, because the dog wasn't in there. We say that the compelling explanation for what ensued had another genesis in the background and attitudes, and unpreparedness to comply with instructions for Mr. Rolf. The fact that the IRT existed, that it had particular weapons, again, is not to the point. It's not indicative of the Northern Territory Police Force becoming militarised. It certainly doesn't go to whether militarisation played a role in Kumanjayi's death. So in our submission, we rely on what's in writing. The level of force used by Constable Rolf is not in the zone into which Your Honour should go. But even were it, the fact that Constable Rolf had military experience sheds little light on what occurred. Now, the Northern Territory Police Force has done something about the issue which has been raised, and we genuinely say it has been useful to reflect upon it, because military service is fundamentally different from what is expected of policing, especially in the community. And we'll emphasise in a few minutes' time the new training that exists for all police who are recruited to think about the differences and to focus upon what the core of their responsibility is in interacting with the community, and not to enter into any interactions with what's been described as a warrior mentality. And that forms part of the training at the very beginning of what is learned by those recruited to Northern Territory Police Force. And to that extent, what's taken place in this inquest, thanks to friends representing Parumperu, has been, we think, a really useful contribution. It has enhanced the quality of training. I propose to say very little about the issue of carriage of guns in community. This is an issue upon which we have to agree to disagree with friends, especially from Parumperu. We hear and empathise with the concerns raised. We note that their arguments have been put specifically in relation to Uendamu, and we do appreciate that there are some features specific to the tragic history with Uendamu in the vicinity dating back to the Coniston massacre. The Northern Territory Police Force remains of the view, however, that in discharging ordinary policing duties, it is necessary for police in Uendamu, like everywhere else in Australia, to have the ordinary accoutrements. The real issue is what is done with them. That doesn't mean carrying rifles. That's a separate issue altogether. But in terms of Glock pistols, we say it is necessary for police to be able to respond to protect members of the community or to protect themselves in circumstances which can arise completely unpredictably. The real issue is when they use them, the controls over them, the supervision of such matters and the training in respect of them. Your Honour has evidence from Deputy Commissioner Dole about this. You have evidence from Deputy Commissioner Smallpage as well. We have looked at ways to find a middle ground and have had constructive discussions with our learned friend about this, and those are not concluded. But what we can say is that there is the possibility for mutual respect agreements to be developed around use about carriage and use of guns in community, and that on the agenda certainly can be refraining from carrying guns in a variety of circumstances. So that's intended as a message of goodwill to Parumperu, and to say explicitly the issue is open to further discussion. Move now to events after the death of Kumanjayi. We say in that regard too that rigour is required in reflecting on what took place and considering what findings properly should be made. That's always difficult when it's a matter that ensued in the aftermath of the death, but consistent with our position of not arguing about technicalities, we want to engage with what occurred. We have conceded already that some of what occurred in the aftermath of Kumanjayi's death is unsatisfactory, and we unequivocally apologise for it. Let me explain just a little further. After the 3 shots had been discharged, there was a very complex situation with distress, of course, being experienced and ventilated by persons in the immediate vicinity, and much fear, no doubt. The first and most important thing was to get Kumanjayi to what medical attention could be provided to him as fast as possible. We concede that he should not have been dragged, but the dragging in this case is not the kind of demeaning dragging that this court and others have had reason to look at. In other cases, it was a mechanism for getting him as fast as possible into the van to get him back to the station, not to sterile circumstances, but to circumstances where what could be done could be provided by way of assistance, and what limited facilities there were at a police station could be utilised. In our submission, it would have been inappropriate to have tried to render medical assistance at the scene, and the key thing was to remove him from the vicinity as fast as possible. It probably could have been done better by lifting and carrying him rather than having part of his body being dragged, and for that an apology has been rendered. Now, at the police station, there are two issues. The first is the failure to invite members of his family to be present when he was in extremis, and the provision of information about what had happened upon his death. Associated with that is the mission. This has been a subject of very extensive reflection by the Northern Territory Police Force. There was a genuine concern about the risk of violence erupting. Now, we've seen some footage, and we make no criticism of this. What we have seen is undoubtedly not everything that occurred, and that footage shows a restrained response by a significant number of people outside the police compound. And the restraint is it's to the credit of everyone involved, no doubt facilitated by Akpo Williams and his father and community leaders. Nonetheless, Ms. Fernandez-Brown did remove weapons from a number of community members. Rocks were thrown. Senior Akpo Williams advised Sergeant Frost and Acting Assistant Commissioner Worst that police were in danger and that community members might try to hurt police. He told Constable First Class Alafeo to lock the door of a police station. According to Warren Williams, some community members wanted to burn the police station down, and a fire was lit, and there was limited information about exactly what was taking place. There had been very substantial civil disturbance in Yuendamu in 2010. Your Honour has heard evidence about occasions in other communities where action was taken against police stations and where there were eruptions of violence. Now, I want to be very clear about this. This is not an attempt to stereotype or legitimise reactions from Indigenous people in a tense situation. It's to say that the lived experience of relevant persons led them to be deeply and genuinely apprehensive. And they made their decisions, we submit, in good faith in that context. With the wisdom of comfort and hindsight in this courtroom, perhaps other things, but we weren't there. We didn't have those fears. It's not reasonable to assert that the decisions to which I have adverted were based on racial bias or ignorance or stereotyping. Notably too, in the course of the ambulance conveying Mr. Rolfe to the airport and then it's returning, significant rocks were thrown and injuries were inflicted personnel. Mr. Rolfe did need to be removed. It was prudent to get him away from the scene, and it was necessary to bring other personnel in to ensure that there was support in case anything adverse did occur. It should not have been done using an ambulance, and to the extent that there was deception, and there was, that should not have happened. Northern Territory Police Force apologises to the health personnel and to the community for it. Senior Akpo Williams was not told of the death of Kumanjayi. That was deliberate, because to have told him and asked him to continue his work with the community, and to have him not tell his relatives and friends in the community, would have placed him in an impossible conflict of interest. The issues to do with provision of mouth-to-mouth assistance and the general provision of care, we submit, have no substance. Energetic, appropriate, and commendable assistance were provided to Kumanjayi, and attempts were made to give him some comfort. It's a second best, of course, to his close relations being present. The reason that they were not invited in was associated with the fear of what results that could engender, and also the very difficult situation that on the floor of a police station was a young man bleeding out, and it's rare to bring close relatives into the dying throes of a person in such abject and distressing circumstances to see it all. Perhaps that was the wrong thing, but that was part of the thinking, and in our respectful submission, it was not entirely unreasonable. It wasn't cruel, it wasn't racist, it was what is usually done in any hospital in Darwin, Alice, or anywhere else. So to attribute that to racism would be unreasonable and unfair. Professor Reid, in fact, concluded that the actions of the police in those circumstances were appropriate. The proposition that Sergeant Frost, as a former no longer registered nurse, should have been directly involved is unreasonable. But whatever fault one might attribute to Mr. Kirstenfeld and to Mr. Rolfe, they had both done extensive battle context training in relation to provision of health care to persons, and in fact their training was more recent, and it was absolutely opposite to the situation that presented. And whatever else one might say about their conduct, in our respectful submission, what they did was entirely proper and commendable at that stage. Afterwards, TRG personnel came to Uendamu, and at least two persons carried long arms to guard the scene at the Red House. That should not have happened. There was no proper basis for it. The community was calm. It was offensive. It was distressing. It compounded whatever distress would have been being experienced by members of the community. It resulted from poor supervision and a misunderstanding of what should and shouldn't be done. It should not have happened. That's no justification, but it's not an example of racism. It's an example of unthinking policing. They had been permitted to bring their weapons, and that was appropriate. What they should have done is to have left them at the police station, not taken them into the community. And again, that is something for which an apology has been rendered. Consideration is being given to provision of specific guidance about when such arms should ever be visible to members of the public when any form of intervention by any police takes place. That's something that's being reflected upon. I'll move to the last phase of what we have to say to Your Honour, and that is in relation to what has happened between 9 November and the present. It is now some 5 years since the tragic passing of Kumanjayi, and much has been done. There is a completely different management team in the police force. There are major changes in staffing. Constable Rolfe has been dismissed. The IRT has been suspended and then disbanded, and there is a commitment not to reconstitute it. There are major reforms in almost every area of policing as a result of what occurred. These have extended to processes of recruitment of new personnel, Aboriginal and non-Aboriginal, training and ongoing education of members, acquisition and enhancement of cultural awareness, policies, including in relation to the use of force, the need for de-escalation in foreseeably risky situations, supervision and oversight of police officers, handling of complaints, undertaking of disciplinary actions against police who have breached their obligations, investigation into deaths, communications with next of kin, managing of fatigue, and other conditions which have the potential to impact upon policing. The Commissioner gave the speech that has been referred to at Gama in relation to relationships with the First Nations people of the Northern Territory. I won't say much about the abolition of the IRT. It has been abolished. There is no intention to replace it under any other name or in any form. I've referred to cultural awareness training. Your Honour's heard quite a bit of evidence about the creation of a Community Resilience and Engagement Command, correct? That was set up in October 2020 to strengthen relationships between the agency and Aboriginal communities. It's really important. It marks a complete reconceptualisation of how new members of the police force are being trained. It extends to cultural awareness, but also trauma information in respect of people who have experienced generational trauma. This involves, of course, the use of ALOs. As of 2 weeks ago, there were 91 ALOs working across the Northern Territory. 3 have progressed to working as ACPOs. 17 applications to transition to constable from ACPO are currently in the system. What we contend to Your Honour is that this is indicative of genuine community engagement. That's also a very important source of cultural knowledge for people in their early stages in the police force and beyond. And it's fundamental that officers engage with ALOs, ACPOs where they exist, and elders in the relevant area so that they can learn and so that they can integrate into the community. Your Honour knows too about the induction manuals. You saw the first one, which had been produced for Uendamu, and that functions as a template for the rest of the Northern Territory. And Greg is assisting in the production of these induction manuals. Some are better than others, some are more extensive than others, some have more hyperlinks to relevant things than others, but it's a start on the road to assisting people to understand more about the local area and how they can learn other things. You know too about the cultural awareness training at the college. In the past, that training was very limited and unsatisfactory, but Craig has developed a 3-day course. A learned friend would like weeks of it. The Northern Territory Police Force would love to provide weeks of training, but financially that's just not possible. It's a start. It may well be that there can be more soon. But of course, you only learn so much in any context at college or at university. If Your Honour thinks back a few years ago to when you finished at university, you had some useful knowledge and skills to start your work as a lawyer, but so much is learnt in the period after that under supervision from people learned and experienced in the profession. So the role for the college is to provide that initial sensitisation and set of values and to lay a basis for what can follow. And that's what CREC is endeavouring to do. It may well be able to do more in due course. It's been the subject of extensive evidence from Senior Constable Wallace and Sergeant Matthew Allen. You know about the instructions that are given in general terms, including input from the Aboriginal Interpreter Service, the Multicultural Council of the Northern Territory, Northern Land Council, cross-cultural consultants, and so on, as well as from ALOs and ACPOs, who are increasingly being integrated into CREC to transfer their information with a practical edge to it to recruits. Since July of 2021, Constable, ACPO and auxiliary recruits have all received culturally responsive trauma-informed care modules during their time at the college. Now, I'm hoping she's still here. Where is she? Yes, she is. Leanne Little. Now, Leanne Little is not an experiment, and she's not a panacea. Leanne Little is a remarkable person. You know quite a bit about her already. She's been the director of the Aboriginal Justice Unit. She's been a principal policy officer. She's been a lecturer at Flinders University. She's been a manager of Aboriginal Affairs and Reconciliation in the Department of the Premier and Cabinet. She's held multiple high-ranking positions in South Australia and the Northern Territory. She is an Arunta woman, a traditional owner. She was awarded the Australian Most Influential Australian Lawyer Award and Change Maker as a change maker. She was the Northern Territory Australian of the Year. The list goes on. She's not tokenistic. She's been brought in by the Commissioner to do a job, and she's expected to do it. However, she's not an experiment, she's not a panacea, and she's not a magic worker either. She's been in place for 5 months now. She's already initiated a range of constructive things. She's working on anti-racism policies and structures. It's called the anti-racism strategy for the Northern Territory Police Force. That involves drawing on and working with others, including the Central Land Council, consultants. It's very important that she work with the Northern Territory Police Association so they are brought with the whole process, and she works as part of the senior executive of the Northern Territory Police Service. Her work is in early stages but looking very promising, and she has the full support of not just a commissioner but of the whole executive. We can't say to you, here's a list of things which she has accomplished yet, but that would be asking too much after such a short time. The strategy is a really important piece of work. It's intended to improve employment and promotional opportunities for Aboriginal members. It's going to have a component about the exercise of discretion. As the head of CREC, she's going to be working to consolidate improvements in relation to recruiting, including trying to elicit issues which might be problematic in attitudes or propensities from persons such as Mr. Rolfe. And she's working to ensure that there is ongoing training for members of the force. She's arranged for Professor David Hollinsworth, who is a professor in Aboriginal Studies at the University of the Sunshine Coast, to deliver anti-racism policy training to the whole executive, to the Professional Standards Command, to the TRG, and to the Territory Safety Division. That's going to be happening in December and January, so just weeks away. These efforts, it is hoped, will supplement others to identify and eliminate racism. I reiterate, any form of racism is not tolerated in the Northern Territory Police Force, and under the leadership of Commissioner Murphy, appropriate measures will be taken against anyone who is found to have engaged in conduct or words which are unsatisfactory. Recruits have been removed from their training who have breached the expectations of them just in recent times. I've referred to the commitment to recruiting and promoting Aboriginal staff. The Australian Institute of Police and Management has been approached to design and deliver an Aboriginal leadership course, and I've referred to the work being done with ALOs and ACPOs to assist transition into constabulary positions. I move now to issues of change in leadership and culture. What has emerged in the course of this inquest is that the roles of sergeants and senior sergeants are particularly influential in passing on culture, not Indigenous culture, but on passing on policing culture to junior officers. If there's a problem with sergeants and senior sergeants, it's likely to be passed on generationally to those whom they supervise. The previous commissioner met with a large proportion of the sergeants in the Northern Territory in relation to what he required of them in terms of leadership and behavioural expectations. That was a major initiative. It meant his sitting down with every single one of them and saying to them firmly, this is what is required of you. If you can't do it, you need to think about doing something else. It is core to what is required of you as a supervisor of junior officers. During 2020 and 2021, Deputy Commissioner Smallpage was involved in it as well. And between Deputy Commissioner Smallpage and Deputy Commissioner Murphy, as he then was, they met personally with each member of the rank of Senior Sergeant, Superintendent, Commander and Assistant Commissioner in relation to those matters. That's a major initiative. These were not friendly chit-chats. They were serious, focused meetings designed to bring home what was required of those with supervisory responsibilities. Commander Dole, as he then was, now Deputy Commissioner Dole, also engaged in a process of meeting with all members of sergeant rank in relation to these matters. A further aspect of the attempt to enhance the performance of sergeants, because that was identified in part as a result of this inquest as an area that required change and enhancement in skills and performance. A sergeant development course was developed covering issues that are diverse, but included rank responsibilities, auditing, discipline, body-worn video procedures, compliance with orders, briefing, culture, risk assessments, and so on. It's a week-long course. It was initially offered to substantive sergeants and then to remote sergeants, because as Your Honour will recall, senior constables often function as remote sergeants in remote locations. It's now been extended to acting sergeants and open to senior or first-class constables as an opportunity for them to advance their skills and their aspirations to move higher in the police force. There have been 15 such courses attended by 274 participants, delivered during 2023 and 2024, and 2 further courses are scheduled for the weeks leading up to Christmas. Now, we've heard what's been said today, and what one can say is that it's evident that Rolf did not receive the guidance and mentoring that might have assisted him. Issues have been raised in respect of the supervision and contributions by Sergeant Kirkby and Sergeant Bowens in this regard. Now, having regard to interactions between Mr. Rolfe and Sergeant Bowens, we can see Mr. Rolfe talking about bush cops fucking up as usual, and Mr. Bowens saying bush coons aren't used for people going after them. Whether or not this was a situation of direct supervision, Mr. Bowens was a person to whom it is likely that Mr. Rolfe looked up, respected, because of his role in the IRT, his background in the TRG, and his general role in the police force. But if that's the kind of role modelling that Mr. Rolfe was getting, it's perhaps not so surprising that he developed problematic attitudes. It's likely that many of them were present already. Now, that wasn't known until, by virtue of Your Honour's ruling, these messages became available. Moving to Mr. Kirkby. In messages 426 to 429, we can see him raising the question to Mr. Rolfe, how does bush time put your application ahead? It doesn't. I know, says Rolfe. Fucking idiots. prioritising lads that go out bush so they can be lazy and do no work. There you've got the attitude of Mr. Rolfe, but more importantly, you've got it being supported by a senior officer to him. And Your Honour will recall the messages 4:30 and 4:31 with Mr. Kirkby saying, sorry about stress caused by losing my shit the other night. Rolfe saying, always ready to make my camera face the other way and be a dramatic cunt for the film. What Rolfe said is problematic, but the role of his more senior officer is especially problematic. Shortly afterwards, number 464, people go out bush because they're fucking lazy. Order of preference is blacks, chicks, gays, and lazy fucks, then Zach. That's the kind of guidance and role modelling the Northern Territory Police Force does not need. It's unfortunately the kind of thing that undoubtedly sometimes happens quietly in the background in what has so often been described as private conversations. We now know about it, thanks to Your Honour's permission to have this material made apparent. The challenge is to know what to make of it. We know more about what Mr. Rolfe really thought, and we know more about what the relevant personnel, Sergeant Bowens and Sergeant Kirkby, thought, but the issue for the Northern Territory Police Force is what to do to try to eradicate these kinds of values. And Your Honour, there's no magic solution to this. If people are burnt out and embittered, alienated, judgmental about some of their colleagues, they're probably not going to communicate that to more senior personnel. Just like Mr. Smallpage and others said they hadn't heard people using racist language, and you heard that from one person after another because they knew not to do it in front of senior officers. So it's a process of attitudinal change and instilling of values and communicating a culture of unpreparedness to tolerate that kind of thinking. But it's a subtle, difficult process that has to bring people with it, not alienate them, and to educate them about what is problematic about it, what's unreasonable about it, and what people need to do if they are burnt out to deal with their issues so that they can function better as police officers. Part of that is sitting down and talking to the relevant persons, even if nothing's known about what they really think. And that's why we say these sessions from the very most senior persons in the force, sitting with sergeants and senior sergeants, have really been a constructive contribution in that regard. We're not suggesting that they're a panacea either. I talked to you about Australian Institute of Policing Management Leadership Training. Sergeants have attended such training. The division of senior officers and less senior at Alice Springs has changed. Multiple changes have been made to recruitment processes, which, just to summarise very briefly, involve a new company, Telegy, undertaking psychometric assessments, new processes where anything comes out part of the way through that's problematic or concerning, free-form interviews taking place with recruits to try to draw out what might be their values in ways which are not dependent upon their giving answers which they think would assist them in psychometric tests, processes for obtaining their ADF medical records, processes for eliminating them from service if there is any kind of a serious infringement which comes to light, requirements to make them do statements which render them able to be prosecuted under the Criminal Code or the Oaths, Affirmations and Declarations Act, a range of new guidelines addressing the obligation to provide criminal histories of the kind that Mr. Rolfe chose not to provide. Reference checks are now being done in a more rigorous way rather than to whoever is nominated in the way that occurred with Mr. Rolfe. So the recruitment processes have been fundamentally changed since the days of Mr. Rolfe, learning from the errors that were made in that regard. and they are now being supervised by Ms. Little to endeavour to incorporate within them as many measures as are possible to identify and elicit problematic attitudes. She has been sitting in senior sergeant interviews herself over the last several weeks and has devised some interesting questions. I won't say what they are in court, but try to draw out from people via a case scenario. It's really quite clever, involving an Aboriginal person, what kind of response they have. And what she's found is that a number of the answers have been really problematic, and that's enabled identification of issues and potential follow-up with the persons involved to educate them and to try to get them thinking in a deeper way about cultural issues. Changes have been made to use of force philosophy and training. I won't go into this in detail, it's all in our submissions at 1216 and following, but in short, there's a new general order in relation to such matters that's been the subject of considerable consultation. There are now 6 steps which must be considered in any risk assessment process, and members are required to think carefully about intended actions when about to become involved in a situation which may necessitate a confrontation. Your Honour can see the application of that to a scenario such as that involving Kumanjayi. The tactical operations model has been fundamentally changed. We have a pictorial illustration of what is required in terms of thinking options, which emphasise safety first, assessment, reassessment, communication, and the absolute heart of it is de-escalation in all circumstances. That forms part of the package that is now delivered to recruits at the training college. The attempt is being made to create a new focus and understanding of these sorts of issues, and it's as part of that there is a module in that particularly counterpoints military experience and policing experience, drawing out what the differences are and enabling discussion about what it is about policing that is fundamentally different to other forms of service. And this seems to have been going well. It's been administered now to 4 constable courses, 3 accelerated recruit courses, 5 police auxiliary courses. What is proposed, we can inform Your Honour, is this, that there's going to be a loop intruded into the training so that there's a reversion to the issue late in the training to enable constables, or recruits especially, to talk about what they've learned in the course of their training that's relevant to those relevant differences. So it's to bring it back, emphasise it further, and really integrate it into their development of understanding of what is required of them as persons providing services in the community. In terms of use of force reviews, now Your Honour's been told about senior sergeants being required to review each and every use of force, and the definition of use of force is low level. So every time anybody does anything of any significance in relation to use of force, senior sergeants now have to look at it. There's an extra independent auditing process that's been in place since August 2022. It's resulted in referrals to the Professional Standards Command for a number of persons. There's also now a mechanism for identifying trends, and that's particularly apposite, of course, to the scenario involving someone like Mr. Rolfe, where there might be a series of concerns raised, matters are being investigated, no final resolution. But this enables the Northern Territory Police Force Risk Management and Internal Audit Division to conduct analyses and to identify trends and patterns so that something can be done about it quickly, and to spot trends more broadly utilising SERPRO. We've spoken about supervisor responsibilities. I won't say anything further about that. Wellbeing measures are being enhanced. Efforts are being made to reinvigorate its peer support program, which is going to be launched or relaunched next year. A chaplain and social worker are now permanently based in Alice Springs to provide support to members in the southern region. There's an independent review of support and wellbeing that has taken place, and its strategy was approved by government in May 2023, and it's in the process of full implementation. There's an early intervention policy as well to try to identify and manage risk factors impacting upon members' wellbeing and thereafter their performance. And the idea again is to enable early engagement with persons who may be showing signs of struggling in some way. It's not intended to be punitive, but to offer support. And that's part of a general approach in terms of management of issues prior to their becoming complaints, and then after they become complaints because someone reports something untoward being done. There's a fatigue management process which has resulted in a policy which has been finalised and is now in force as of today. The attempts are being made to undertake long-term work in relation to resource allocation and staffing. This is an issue that's been raised by the Northern Territory Police Association. They're being listened to at the highest levels in the police force. Work's being done to try to improve conditions for those in remote areas in every sense, both physical ones and also their responsibilities and the breaks that they get from their responsibilities, recognising how burdensome that kind of work is. And that's going to be a subject of ongoing discussion, for instance, with the association. Another initiative is the role of the Territory Duty Superintendent to oversee all serious or significant incidents occurring in the Northern Territory outside business hours. And that provides another mechanism for intruding sophisticated, more experienced risk management strategies and decision making. It's a dedicated permanent role, performed 24 hours a day, every day, and it's supported by the Territory Intelligence Section. There are 5 members who occupy the role of TDS, and but there's a dedicated email so that when anything comes in, it's seen by whoever is functioning as the Territory Duty Superintendent at the time. I've made a brief reference to a Professional Standards Command. It is accepted that the responsiveness in terms of timeliness and quality left something to be desired in relation to a number of the matters involving Mr. Rolfe. Efforts are being made to improve that. Your Honour knows that the Galliot review was undertaken externally. There's been a commitment to implement that. Flowcharts have been developed, template forms have been reviewed and updated. A memorandum of understanding has been entered into with NAJA in relation to enabling footage to be viewed before formal complaints are made. PSC is receiving extra training in relation to cultural matters. They've been instructed formally to consider complaints comprehensively and to engage with the Ombudsman's Office to discuss matters of concern and progression. And there has been a resumption of the use of Section 14C for matters that are not so serious. There's a prosecution's review panel, which would have dealt with issues arising from the concerns articulated by Judge Borchers. And that is called the Prosecution's Review Panel meeting, which takes place, as you would think, each month to review what are termed failed prosecutions, but that means acquittals and withdrawals and cases where an issue has been identified which resulted in an issue. And today's comments, such as those from Judge Borchers, would be reviewed immediately by the Prosecution's Review Panel, providing an opportunity for immediate response, for instance, referral to Professional Standards Command to look again at what took place. The attempt has been made to implement if I can call it, the spirit of Galliot, which is to engage the confidence of the police force while taking firm and decisive action in relation to serious matters. There evolved, from a perspective of Commissioner Murphy, a lack of confidence on the part of many in the police force in what PSC did, and an adversarial stance in which many persons availed themselves of every opportunity for appeal, and there were delays and all manner of problems. The Galliot report identified those. It recommended that there be a less adversarial environment with a focus on modern managerial practices, I quote, that are preventative, efficient, effective, and protect the physical and mental health and well-being of all employees. That is the attempt that's being made. It involves a culture shift within PSC. And the early indications are that the PSC is operating less as a silo and more as an integrated component, if you like, of supervision of members. That is the aspiration and the attempt that's being made. The PSC is engaging in educative processes, going out and speaking to members in stations around the Northern Territory as part of a more accessible, less intimidating, and more as part of a mechanism to enhance education of what's required of members. So, in summary, Your Honour, you can hear a great many measures have been undertaken. We know Your Honour doesn't like words or empty rhetoric, and we've supply you with facts and information about actions that have been taken. We hope that you will interpret those as indicative of goodwill and attempts to respond to things which have been learned and needed to be learned by the Northern Territory Police Force. Not everything has been solved. There is a good deal of further work to be done, but there are people of goodwill, and there are, it's fair to say, more sensitised senior members of the police force to issues which have been uncovered in the course of this inquest. There is every reason, we submit, to be optimistic that the police force has learned lessons and is making progress in providing better policing services than existed at the time of Kumanjayi's tragic passing. And we very much hope that those who loved and valued Kumanjayi Walker can derive some modest comfort that they have been listened to and many changes have been made and more will be made. Thank you for listening to us.
Thank you, Dr. Freckleton.
Your Honour, before I commence with my reply, I've received 2 text messages from Mr. Officer while Dr. Freckleton has been speaking. One is this comment: I would like to have it on the record that, contrary to what Dr. Freckleton said, I did deal with the duty to make findings about circumstances of death at transcript 5890 and transcript 5891. So no doubt you'll have a look at that. And I just received a message that Mr. Officer has one matter to raise collectively, which he says will take no longer than 2 minutes.
Does he propose to do that on the...
I think I can hear him now.
Can Your Honour hear me?
Yes, I can.
Thank you, Your Honour.
I can hear me too. Just hang on a second.
As they're getting some feedback, Your Honour.
Yes. Maybe if you reduce your volume.
I've done so, Your Honour.
The other thing is I can just stop talking and we'll just listen to you.
Thank you, Your Honour. I'll make the point brief. Your Honour, Dr. Freckleton said today, in reference to the racism word, or the word racism, that he's not uncomfortable naming the word or naming the people. That's why we've straightforwardly characterised the sort of person that Rolf is. And he also mentioned in his submissions about positions that parties have taken as to Rolf's candour or frankness. Your Honour, as a matter of fairness to Mr. Rolf, Your Honour should be careful not to single out Mr. Rolf. There's a curious absence by Dr. Freckleton to refer to those for whom he acts, that is, the members of the TRG, who equally engaged in highly inappropriate and racist and offensive behaviour and lied to Your Honour in statutory declarations. And Your Honour should also take account, but it's notable that there was an absence of reference to that and singling out Constable Rolf or Mr. Rolf by Dr. Freckleton in his submissions. You should take that into account. Thank you.
Thank you, Mr. Officer. Yes, Dr. Dwyer.
Your Honour, briefly and strictly by way of reply, might I deal firstly with two procedural issues raised on behalf of firstly Sergeant Bowens and then Mr. Rolf, and then turn to 2 brief substantial matters. Firstly, You will recall, Your Honour, I said that I would MFI a document when I dealt with the complaint made by Ms McNally in her oral submissions. The first complaint that she made with respect to any issue of procedural fairness concerns funding and the suggested inability of her client to participate fully because her client, she says, was not fully funded. You would dismiss that, in my respectful submission, as anything that impacted on procedural fairness for these reasons. Firstly, to make it clear, because the public, many of the public are listening, the Coroner's Court doesn't allocate funding to parties to participate in an inquest. The coroner determines whether or not parties have a sufficient interest to appear on behalf of, or to appear in, and therefore they then go and seek legal representation if they do have sufficient interest. Sergeant Bowens was given a right of appearance and to be legally represented, and that was at large. There were no restrictions placed on what he might assist Your Honour with. Once parties have leave to appear, they then go to their employee, often, or sometimes a union, for funding. Sergeant Bowens approached his employer, and I understand was funded to appear in these proceedings in the ordinary course, as witnesses do, including police officers, current and former, in inquests throughout Australia. Sergeant Bowens did that in the ordinary course, as did Sergeant Kirkby, and Your Honour will recall he was represented by Mr Robson as senior counsel and then Mr Fernandez. Officers Ebel and Hawkins applied for leave to appear, were granted leave and were represented by counsel Mr Reid of senior counsel. Former Superintendent Pollock was granted leave to appear and was represented by Mr Castleton. Officers Kirstenfeld and Nankivell were represented by Solicitor Advocate Mr Gannegg. And they appeared as required. Clearly not all of those officers' evidence was relevant to all the sitting days involved. And so those lawyers engaged in discussion with counsel assisting about when they, and informed the court when they would appear. So that complaint just has no substance. The second complaint made was a complaint about the failure to be able to provide documentation or evidence to the court. That is a nonsense. And I read onto the record an email which post-dated the email correspondence that Ms McNally selectively refers to in her written submissions. That was an email dated the 20th of September 2023, where after it's clear, as I indicated this morning, that Ms Wells indicated that she was happy to engage with a discussion with Ms McNally about whether they wanted to prepare a schedule for a summons or whether or not they wanted to provide the evidence voluntarily. No further interest was shown by Ms McNally in providing a schedule, and then subsequent to that, on the 20th of September 2023, there was an open invitation which made it blatantly obvious that not only was the Coroner's Court prepared to accept any evidence from Sergeant Bowens, but it would welcome the evidence that Sergeant Bowens could give because, and I quote from Ms Wells' email, he's in a unique position to provide helpful evidence to the court about a number of matters, including, for example, the resourcing and operation of the IRT. And Ms Wells goes on to explain that he could provide that material by way of an attachment to the statements. So I wouldn't bother to MFI correspondence between lawyers unless it was directly relevant to what is put by way of complaint on behalf of Sergeant Bowens selectively and unfairly. And so I ask that that be marked for identification. Further, Your Honour, attached to that, and this part can be marked at the same time, is a letter dated the 27th of March 2024. Your Honour will recall that a further complaint made on behalf of Sergeant Bowens is that he wasn't given any notice of any adverse comments that might be made. That's a nonsense for a number of reasons. He participated in these proceedings. He was provided a letter on the 27th of March 2024, which outlined the allegations that Mr Rolfe made about racism within the TRG and revealed the fact that there'd been racist certificates, which then led to Your Honour discovering that one of the racist certificate awards was given to Sergeant Bowens. He was put on notice of that very fact and then provided to provide a statement about it, which he did. And then the written submissions of counsel assisting and the other parties are exchanged for the very purpose, or for one of the purposes, is to give parties notice of potential adverse comment. So I withdraw that. I ask that they be marked for identification.
Yes, that will be marked for identification as one bundle.
Triple Y, Your Honour.
Triple Y. We'll put a staple in it.
Thank you, Your Honour. The second issue, and by way of a procedural complaint, was made by Mr Officer on behalf of his client. And I just reply to the one that was dealt with in some detail in Mr Officer's oral submissions. That is his complaint that no party put to Mr Rolfe in evidence the body-worn video that shows what he says is evidence of Mr Walker with his hand on Mr Rolfe's gun. As Your Honour knows, throughout the course of these proceedings, arrangements were made for parties to be able to show documents or show video footage, body-worn video footage or other footage. And they only needed to ask Ms Walls to assist them, to get the court officer to put that up on the screen or to provide whatever arrangements were necessary to show those documents or that video to a witness. That was done on countless occasions throughout the course of this inquest. It was done indeed by Mr Officer or Mr Edwardson when they were cross-examining witnesses on behalf of Mr Rolfe. But specifically, in relation to the examination and cross-examination of Mr Rolfe, Mr Officer knew that Miss Walls and this court and Your Honour's court officer would accommodate any arrangements that were requested. So on the 1st of March 2024, Mr Officer sent Miss Walls an email saying, "Dear Maria, in anticipation of my examination of my client, I may take the witness to the following: 3-110, 10-116 and body-worn video, actual incident, Rolfe 2 of 4. And I ask that that be marked for identification. And it just demonstrates how unhelpful it is to complain about these issues so unfairly.
That's MFI.
Z.
We want to object to that, guys.
Mr Officer, we are having difficulty hearing you.
Yeah, how about now?
It might be that we need to get you on a phone link instead of over the, I don't know what device you're using.
I'll do that now, Your Honour.
All right. Does someone have a number that we can contact him on?
Hello, Luke. Speaking.
Hi, Mr Officer.
Hi, Your Honour. Can you hear me now?
Yes.
Your Honour, I object to that being MFI'd for these reasons. Firstly, whatever I put in an email to anticipate what I might examine my client on is a matter of convenience, as counsel assistant has been at pains to say, to give Ms Walls notice of anything we intend to take a witness to, so it ensures the smooth running. That does not mean that is how I will examine or what I will examine on. Secondly, as I made clear yesterday, I've made clear in written submissions and as the Peru Committee have made clear, Mr Rolfe has no obligation or duty to your court to prove anything. Thirdly, the complaint I made about the fact the body-worn video is not played to anyone is not a complaint that no one has played it. The complaint is simply a submission where, if parties want to put something to a witness or suggest you can infer something or you can see something or not, then that was the opportunity that Mr Rolfe should have been presented with that body-worn video and asked to identify where he says he could see, or on the video it might show, Mr Walker, Kumanjayi Walker, reaching for his gun. Your Honour, to try and identify an email...
Sorry, Mr Officer, I'm really sorry to interrupt. He had that opportunity. All witnesses had an opportunity, particularly represented witnesses like Mr. Rolfe, to play any evidence that they wish to and point out anything on any of the tendered evidence or tender additional evidence if they sought to do so. So he had that opportunity.
But Your Honour, that's reverse engineering the end game. Parties want to suggest that it was a fabrication and a lie, and because he doesn't point out on the body-worn video where it happens, that somehow he expected his counsel to make that forensic decision and to expect that we have to prove something is not how it works, Your Honour. If parties want to suggest it was a fabrication, they should have put it to them or put it to Mr. Rolfe. You tell us where on the body-worn video you say it happens, and then so on the questions go from there. Oh, you can't see that, Mr. Rolfe, or you can see that. It's not the duty of the lawyers for Mr. Rolfe to prove anything, Your Honour. That's the complaint we make. It's not the complaint it wasn't shown per se. It's the fact that you can't expect an inference to be drawn by counsel not asking a question when the evidence is in from Rolfe himself. If parties want to challenge that, that's up to them. That's the purpose of the complaint.
It sounds, Your Honour, like Mr. Officer accepts that if he wanted to, he could have shown the video to Mr. Rolfe. On that basis, I don't need to press that become an MFI. It's abundantly clear in my respectful submission that he had every opportunity to show the video, and that's my submission.
Well, Your Honour, it's wrong as a matter of law.
Mr. Officer, the video is in evidence. The submissions are closed. However, other than the submissions in reply. However, if there is a matter that you would like to make a further submission on, including in relation to asking me to view a particular part of a video which you think is very relevant to these proceedings, and you would like to point out what part of that video it is, I will receive that submission.
Thank you, Your Honour. I'll consider that.
Would you want to just give Mr. Officer a time frame for doing so? Because
yes,
respectful submission, we need to finish.
That's by close of business tomorrow.
Thank you.
Your Honour, moving on to substantive issues then, and briefly. Just one matter, and that concerns the evidence of Mr. Alafeo. The reason I raise it again is because Mr. Alafeo was a key part, of the morning arrest plan that was devised by Sergeant Frost and approved by hierarchy within the Northern Territory Police. It's part of the reason it was a much safer option than the approach taken by Mr. Rolfe when he abandoned that plan and determined to enter House 511 on the evening of the 9th of November rather than the following morning. And that is, of course, in part because Mr. Alafeo had a relationship with Mr. Rolfe. I withdraw that, had a relationship with Mr. Walker and could recognise him, removing the need for any identification such as that took place where Mr. Rolfe got in very close proximity and held his phone up to Mr. Walker's face. The evidence of Mr. Alafeo not read by Mr. Officer when he made submissions includes this during the inquest. On the 20th of September 2022, when he was being examined by Mr. Coleridge, he was asked open questions by Mr. Coleridge, and they included these. What, if anything, did Sergeant Frost say about the plan? The response, Your Honour, it was more like a quick briefing she gave to me, and if I recall, she wanted me to be there and assist the IRT that were coming later on in the day and to go with them in the next morning. Mr. Coleridge asked the question, can you recall what time? Answer, she mentioned that to meet up at the Yuendamu police station at 5 o'clock in the morning and to leave at 5:30 in the morning. Question, now I think you said the word assist the IRT? Yeah. Open question asked by Mr. Coleridge. What was the nature of your assistance to be? Answer, I believe it was just to be there because of my knowledge, local knowledge of Yundamu, and also the relationship that I have with Lottie Robertson and Eddie Robertson, who are carers for Kumanjayi at the time. So I was pulled in to hopefully communicate with them, ask them of his whereabouts, and also I know Kumanjayi very well, and I can, like if I say I can identify him, I know him, and I can point him out to TRG, he means of course IRT, if that's him. Okay, was it proposed that you be physically involved in the arrest? No. Sergeant Frost made it clear to me that I won't be involved in the arresting of Kumanjayi, but after the arrest I'll be involved in the watch house processes back at the station when we get to the station. So it was very clear in that open exchange that he understood that the plan was that he meet the officers at 5 a.m, go out at 5:30 a.m, be there as part of the arrest plan to assist with the communication and the identification of Kumanjayi. The final submission I make is in response to a submission made by Dr. Freckleton on behalf of the Northern Territory Police. Dr. Freckleton, of course, has made very significant submissions on a number of issues, and I don't propose to address all of them or many of them. He's made very significant submissions in relation to the racism exhibited by individuals and the assertion by some parties of institutional racism and what Your Honour should find in that regard. And that will no doubt require Your Honour's careful attention and review of the submissions, the evidence before Your Honour and any relevant case law. The only thing I propose to say by way of reply is this, Your Honour. Dr. Freckleton concedes that certain attitudes of Mr. Rolfe may be relevant to his actions on the 9th of November that led to Kumanjayi's passing. They include attitudes of sexism, contempt for authority, contempt for bush cops. Dr. Freckleton concedes that Your Honour may take those into account in determining that is part of the reason why he disregarded the 5 a.m. arrest plan and thought his approach was better. My submission in reply, Your Honour, with respect, is that Zachary Rolfe, the whole person, came to Yundamu on the 9th of November 2019. And the whole person was someone who could behave in polite ways at times and who behaved in a way, and Mr. Officer urges Your Honour to take into consideration of where he was thoughtful on occasion and received commendation on occasion. The whole person was someone whose attitudes were sexist, contemptuous of female police, contemptuous of some superiors, and contemptuous of bush cops and racist. And so I remind Your Honour of the evidence given by police psychologist Mr. Van Heften when asked a question or series of questions by Mr. Officer. Mr. Officer began his questions, if a police officer has never been involved in a situation where in very quick time they are subjected to a rapid and violent assault, it wouldn't necessarily be an instance where they'd been desensitised and exposed to those situations. He went on to say in those unique events, when we talk about characteristics and having in mind your qualifications, is it the case that an individual in that situation would fall back on their training and decisions they make in the moment? And the answer, I would say the decisions that they make, as well as the training, will be influenced by their attitudes and values. The decisions Mr. Rolfe made on the 9th of November 2019, Your Honour may find, were influenced by his attitudes and his values. And they included attitudes of sexism, contempt for female police, contempt for some superiors, contempt for bush cops, and racism. May it please the court.
Thank you. These past 2 days have been important and they have been very helpful to me in the task that I am now about to undertake. I wish to thank all counsel for their detailed written submissions and thoughtful oral submissions. All the submissions will be carefully considered. It's my intention to list this matter again, likely in late February 2025, to hand down my findings and we'll adjourn now.
Sorry, Your Honour, just one matter from Mr.
Sorry.
Your Honour, I apologise in advance not having had a chance to fully discuss this with all the relevant persons, but it's a developing matter over today, and I do have instructions now to invite Your Honour at least to consider delivering the findings and recommendations of the inquest at Yuendamu. And I appreciate this will be unexpected, and so I'm putting it in that way. Your Honour has been invited, and I'm rephrasing that to say that Your Honour can at least consider that invitation, and no doubt there'll be some correspondence or whatever there will be later about how that idea develops.
Thank you. And I have indicated firstly that it was my intention to list the matter likely in late February 2025. And I understand that we will be consulting with the community as to the appropriate timing of the handing down of the findings. There may be community matters which affect the date, and I also have not indicated where that will be.
Thank you, Your Honour. And
So,
yes, there are often February community matters. Thank you, Your Honour.
thank you. But we'll now adjourn.
Silence will stand. The Coroner's Court of the Northern Territory is now adjourned.
I feel so sad. We might not all be here like this together again.
Yeah.